My name's Tamara Dini. I'm a director at Bowman Gilfillan in the Competition Law Department. I'm in our Cape Town office. I'm going to be speaking briefly about the Competition Amendment Act. The Competition Amendment Act is expected to enter into force within the first quarter of this year. It will introduce significant changes to South African competition law. Its provisions have been widely debated and are fairly controversial. One of the most controversial aspects of the Amendments Act is the introduction of criminal liability for directors and for managers or other employees of a firm who hold a position of management or have management authority. Essentially, if a director or a manager has caused a company to engage in cartel activity or has acquiesced in the company engaging in cartel conduct, that person may be liable for a fine of up to 500,000 rand or imprisonment of up to 10 years or both. The firm concerned may not reimburse the director or manager for the penalty that may be imposed on them, nor may they be covered by the firm in terms of their legal costs being paid for. So this is really a provision that aims at ensuring accountability of directors and managers and also seeks to deter cartel conduct. The Competition Amendment Act has been criticized because of the reverse onus that is established, really where a firm concludes a consent order with the Competition Commission, or if the Competition Tribunal makes a finding that a firm has engaged in cartel conduct, this consent order or the finding by the tribunal will be prima facie proof in court proceedings against an individual for the criminal offence. So generally the state is required to prove its case beyond a reasonable doubt, and for this reason the amendments have been criticised as violating the constitutional right to be presumed innocent and the constitutional right to remain silent. One of the further concerns with the Competition Amendment Act is that the criminal liability provisions may have a chilling effect on corporate leniency applications. Because of the exposure now for managers and directors, there is a sense that people may be more reluctant to come forward and to whistleblow on cartel conduct. The Commission's corporate leniency policy in the past has been one of the most effective enforcement tools in helping the Commission uncover cartel conduct.
My name is Nadisha Singh, and I am a Senior Associate in the Competition Law Department of Bowman Gilfillan Attorneys. Today I will be talking to you about the recent shift in the focus of the Competition Commission from merger activity to enforcement of the Competition Act. For a few years now, the Competition Commission has shifted its focus from merger activity to the enforcement of the Competition Act. The Commission has been engaging with a number of key players in what the Commission describes as its key priority sectors of the economy. The Commission has prioritized the following sectors as key priority sectors, namely the food and agro-processing sector, the infrastructure sector, the financial services sector, and the intermediate industrial products sector. The Commission has identified these sectors as being particularly important for the alleviation of poverty, the creation of employment, and the stimulation of economic growth within the economy. Between April 2008 and March 2009, the Commission has initiated a number of investigations in its key priority sectors and has levied penalties totaling a record of 331 million rands. The Commission has prioritized the food and agro-processing sectors because of the employment involved in this sector and because of the fact that it produces essential food products bought by all consumers, particularly low-income households. There has been increasing widespread public concern over escalating food prices, which have grave implications for all consumers, but particularly the poor consumer. Anti-competitive conduct, such as collusion, results in food prices rising above a competitive level. The Commission has recently conducted investigations in a number of food product markets, including the bread, milling, and dairy product markets. The Commission has prioritized the infrastructure sector because the government has recently embarked on a number of major investment programs in this sector, and these programs could potentially be undermined by anti-competitive conduct. In the construction sector, the Commission has initiated investigations in a number of product markets. These product markets include steel products, brick, wire, and cement. In addition, cartels operating in the concrete pipes and plastic pipes product markets have been referred by the Commission to the Competition Tribunal for prosecution. Competition concerns in the financial services sector arose from the fact that there has been a high level of concentration amongst almost all banking product categories, and there's been little evidence of rivalry amongst the largest 4 banks in South Africa. Fees were also high, and these were increasing rapidly, and this was felt particularly by low-income consumers as well as small and medium businesses. There was also substantial public concern over the increase in the level of bank charges levied to consumers. The financial services sector is of particular significance as more competitive financial services means that the cost of capital provided to small and medium businesses is reduced. Low bank charges and fees would also make banking services more accessible to low-income households. With regard to the intermediate industrial product sector, intermediate industrial products includes basic chemicals and basic metal products, which are key inputs in the manufacture of various industrial products. Prices in these areas have in recent times risen in excess of producer and consumer inflation rates. The Commission has a number of ongoing investigations at the moment in the steel and polymers markets. The Commission's corporate leniency policy has played a crucial role in the Commission's enforcement of the Competition Act. The Commission's success has been boosted by its corporate leniency policy, which aims to detect and prevent cartel behavior by providing immunity from prosecution to the first cartel member which approaches the Competition Commission with information about cartel conduct. It is therefore clear that the Commission has prioritized the investigation of anti-competitive conduct in markets that affect the poorer consumers. It is likely in the current year that the Commission will continue with its enforcement efforts in its key priority sectors.
My name is Rudolf Labuskaghni. I'm a partner at Bowman Gilfillan's Competition Law Department in Cape Town. I'm going to talk a bit about the issue of civil damages claims in competition law and regulation in South Africa. Now, the South African Competition Act provides that any person who has suffered a loss or damage as a result of a prohibited practice is entitled to institute an action for civil damages in any civil or competent court in South Africa against the offending firm or firms involved. In order to institute a civil action, a prospective claimant is required to obtain what's called a certificate from the Competition Tribunal or the Competition Appeal Court, certifying that the particular conduct has been found to be a prohibited practice as defined in our South African Competition Act. Claims for civil damages differ from administrative penalties in 2 important aspects. Firstly, administrative penalties are paid over to the fiscus and are ultimately deposited into the National Revenue Fund. Civil damages, on the other hand, are paid over directly to the claimant concerned, whether it is an individual, corporation, trust, or any other entity. Secondly, administrative penalties are limited to 10% of the offending firm's turnover. A claim for damages, however, is limited only to the actual harm or damage suffered by the claimant and could, in theory, be much higher than 10% of a firm's turnover. In South Africa, up till now, no civil damages claims have been heard by our courts. The closest we came to creating case law on this subject was in 2007, when Nationwide Airlines instituted a civil damages action against South African Airways for having abused its dominant position in the domestic air passenger market. Ultimately, that matter was settled between the 2 firms involved, and details of the settlement have remained a closely guarded secret. In recent times, and in particular flowing from the Competition Commission's uncovering of the bread price fixing cartel, the issue of civil damages claims has been receiving quite a lot of attention in the media. One aspect of civil damages claims that is of particular interest is the aspect of the so-called American-style class action lawsuits. In terms of a class action lawsuit, several claimants are able to pool their claims together in one consolidated action against the respondent. Although South African law does not specifically provide for class action lawsuits, it also does not specifically prohibit them. From recent comments by several judges, legal commentators, and legal practitioners, it seems likely that the class action lawsuit will receive favorable consideration by our courts when confronted with them. Allowing for class action lawsuits will undoubtedly make it easier for individuals and smaller firms who might otherwise not have the financial means to do so to institute action for civil damages against respondents who have contravened the Competition Act.